A very good evening to all of you. Ms. Anna Jubin-Brett, Secretary of UNCITRAL. Mr. R. Venkatramani, the London Attorney General for India. Dr. Rajkumar Ranjan Singh, Minister of State for External Affairs. Mr. Fali Nariman, eminent senior advocate, thinker, mentor, visionary, and chairperson of the UNCCI, distinguished colleagues in the Supreme Court, of the High Courts, Your Excellencies, and ladies and gentlemen. At the outset, I would like to congratulate UNCITRAL, the Ministry of External Affairs of the Government of India, and the UNCITRAL National Coordination Committee of India for their joint effort in organizing this event, which reinforces India's decades-long engagement with UNCITRAL and facilitates the exchange of ideas and perspectives among South Asian countries. I'm truly delighted to be able to deliver the inaugural address at the South Asia Conference, which was last held in India in 2016. I had the undiluted pleasure of being in the audience in that conference, in the inaugural session. Then too, I had the pleasure of attending the conference. I believe that the conversations which take place at such events serve as a sounding board for ideas that morph into best practices. Some of those best practices are incorporated into law. We have each amassed years of institutional experience, and through deliberative efforts such as this conference, are able to share insights from our own experiences with one another. Even as our own experiences guide us, we must each learn from other countries and the successes and difficulties that each country has faced with its people, business, and legal systems. There is no point in brushing our failures under the carpet. This is all the more possible in this conference because South Asian countries have much and more in common. The many similarities in our cultural and social setup undoubtedly seep into our business practices and legal systems. Our economies are also interconnected, increasingly so in the digital age. Platforms such as Instagram have emerged as unlikely online marketplaces which facilitate business among the countries in South Asia. Our legal frameworks must be in tandem with the expansion of the digital economy. I'm happy to share with you that last week, India and Singapore, through their Supreme Courts, signed a Memorandum of Understanding on advancing cooperation in judicial education and research. This is one of the many MOUs that India has signed with South Asian nations that foster knowledge sharing and collective advancement. Our judiciaries are working in tandem. UPI has entered into a connection with Singapore's national platform for payments. When countries walk hand in hand, the progress of one becomes the progress of all. A tainted relationship, legal or otherwise, begets distrust. The parties battling this distrust must now brace for a legal battle and attempt to resolve their disputes. This is already a daunting and expensive process for most entities. Legal battles once begun have no end in sight. Ask me as a judge. And throw cross-border laws and international parties into the mix, and you have a dispute that makes for an even more expensive, time-consuming, and oftentimes confusing affair. As members of the legal community, we know better than anyone that this is hardly a profitable phenomenon, perhaps except for us, especially for smaller and mid-sized enterprises. Alternative dispute resolution mechanisms were previously considered to be rough justice, an imperfect substitute for judicial review by courts. Parties and jurors alike perceived arbitration and other out-of-court mechanisms as a deprivation of the opportunity to have their day in court. I believe that at least a part of this hostility stemmed from a lack of transparency about the procedures to be adopted and a lack of clarity as to the outcome of a challenge to a final arbitral award. Of course, new ideas and processes are initially viewed with mistrust. We have now moved far beyond this atmosphere of mistrust into calling ADR as appropriate dispute resolution mechanisms our first line of fora for efficient, transparent, and certain dispute resolution. Sunshine, as they say, is the best disinfectant. Fortunately, UNCITRAL assisted countries in the simplification and uniformization of their laws and rules, which in turn has made the justice delivery system more accessible. The UNCITRAL model law framework seeks to harmonize laws in different jurisdictions in an attempt to overcome the friction that may result from our diverse cultural and legal landscapes. The success of its model law framework requires no explication. India's law on arbitration and conciliation has relied on the UNCITRAL model law. Legislative efforts in India in ensuring clarity as well as judicial trust on party autonomy significantly reduce the sense of unease amongst contracting parties. With its eye on best practices, India has steadily charted a course where arbitrations are the preferred mode of dispute resolution. The Indian Council of Arbitration, our first ever national arbitration institution, was established in 1965. We now have about 35 such institutions across the country. There is a veritable competition for good governance among states in business dispute resolution. Typically, we think of federalism as a political concept, but truly, the Indian federal structure is now becoming a platform for healthy competition among states to produce the best business outcomes, including in dispute resolution. The Delhi International Arbitration Center, for instance, went from handling 78 cases in 2009 to 5,868 cases in 2022. In 2013, a survey of corporate outlook towards arbitration described India's future as an arbitrating country as cautiously optimistic. Today, I take the liberty to state that India's future as an arbitrating country is cemented. Mediation and arbitration result in a significant reduction of costs for the parties to the dispute. These savings are particularly beneficial for smaller or mid-tier enterprises who will not be required to shell out large sums by way of legal fees for court proceedings that may take years to conclude. As legal fees explode through the roof in India, the bottom line is engaging the attention of corporate India as well. Indian courts have encouraged the use of ADR mechanisms over the years. In enforcing arbitration agreements, they have remained watchful of attempts to undercut party autonomy by artfully drafted contracts. In ICOM Tele Limited versus Punjab State Water Supply and Sewerage Board, a decision of 2019, the Supreme Court struck down a term which required a party to deposit 10% of the dispute value as a precondition to invoking arbitration. In NTPC Limited versus SPML Infra Limited in 2023, one of the parties to the agreement in question sought to initiate arbitration, even though there was a settlement between them. A Supreme Court bench of which I was a part reiterated that disingenuous litigation cannot be tolerated in the name of party autonomy. I would also like to take this opportunity to share some recent initiatives of the Supreme Court of India with you. How can I miss this opportunity as the head of the family? In India and in other countries as well, private players are perceived as being technology friendly, while public institutions are thought to live in the Stone Age when it comes to the adoption of latest technologies. This is perhaps not an unfair perception, because government offices and courts are often late to the party. But lawyers and litigants have had cause to celebrate of late. From e-filing and record keeping to real-time information systems, everything is being done digitally. Electronic case management systems are available at the click of a button. Today, the Supreme Court of India has onboarded all its data on the National Judicial Data Grid in a new era of transparency and accountability. The Supreme Court issues entry passes through a virtual platform, almost 700 of them which are issued every day to people who visit our court. We live stream hearings of certain constitutionally significant cases, and we release transcripts of oral arguments in those cases. A friend once told me, a few days back in fact, that watching one of these live hearings on YouTube was better than watching a Netflix movie on occasion. These initiatives are with a view to making the courts accessible to the common person. I dare say that some of our technology-based initiatives have surpassed those of arbitrations. I was intrigued by the clout or the case law on UNCITRAL texts, an open access resource that contains decisions of courts and arbitral awards relating to UNCITRAL texts. A summary of these cases is made available on the searchable cloud database. I'm sure some of you would have benefited from the immense industry that has produced this resource. Similar to the cloud resource, the e-Supreme Court resource, the e-Supreme Court reports, or the electronic version of the Supreme Court Reporter provides free access in a searchable format to about 34,000 judgments of the Supreme Court of India since 1950 to lawyers as well as members of the public. All judgments are uploaded on the platform within 24 hours of pronouncement. In the interest of uniformity and harmonizing the manner in which the judiciary in India functions, we recently introduced a uniform citation system or a neutral citation system, which is now being followed across India. Like cloud, these initiatives aim to democratize access to information. The democratization of access to knowledge has helped break down monopolies based on old feudal structures. We are on the anvil of having a digital SCR in the very near future. The Supreme Court of India is launching into AI-assisted learning very shortly. Our judgments are being translated into every language which the Constitution recognizes. 9,000 of our judgments have already been translated into Hindi, and we are aiming to translate judgments using machine learning tools in all our languages to reach out to people, to make sure that the work of the Supreme Court is not just confined to lawyers and judges and academics, but reaches out to the homes of every Indian. The Supreme Court is about to enter into a memorandum of understanding with the Indian Institute of Technology at Madras with a view to leveraging AI into the work of the Supreme Court. As we tackle barriers to information and resources, we should begin to look beyond our traditional destinations for arbitration. Disputes are location agnostic, and so should their resolution be. Many businesses from Tier 2 and Tier 3 Indian cities have a commercial presence across the globe. This is undoubtedly true for businesses located in smaller cities in the countries of South Asia. Such parties who are not located in metropolitan cities must have equal access to resources which enable ADR. This conference is the ideal place for such a decision to begin. But it must not end here. We must find a way to make smaller businesses a part of our conversation in law. I'm told that UNCITRAL Working Group 3 is discussing investor-state dispute settlement reforms. I recollect addressing this topic in 2016 during my panel discussion at the UNCITRAL conference here in Delhi. At that point, the question of whether UNCITRAL should address ISDS reforms was unsettled. We have come a long way, COVID notwithstanding. At that point, the question was completely unsettled. Since then, the UNCITRAL Commission has just adopted the first text on ISDS reforms pertaining to the Code of Conduct for arbitrators and judges in the ISDS process, as well as mediations which take place during this process. This is an example of the pivotal role played by India at UNCITRAL, and particularly in having this topic allotted to a working group. The global community is yet to reach a consensus on some issues regarding investor-state disputes. For instance, some bilateral investment treaties envisage a permanent court as a forum for the resolution of disputes instead of arbitral tribunals, which have traditionally been the forum of choice. Such developments must be discussed by UNCITRAL's working groups. International investment law has been criticized for being disadvantageous to developing countries, particularly those in the global south. It is therefore essential that the formulation of any new systems in international investment law, such as the creation of a permanent court, adequately account for these concerns and ensure that they do not remain areas of concern. I'm glad that the Secretary General of ICSID, Ms. Meg Kinya, is here and will be speaking at the conference. While India is not a member of ICSID, it appreciates the contribution of ICSID to the various deliberations under the auspices of UNCITRAL. The need of the hour is a fair and balanced system for the resolution of investor-state disputes. If such an investment court were to become a reality, we must explore the possibility of floating courts instead of the traditional system where all parties travel to a single place where the court is located. This would make the court more accessible to all countries across the globe. The host country agreements with the PCA are one of the avenues by which this could be achieved. Perhaps it is also time for India to revisit its host country agreement with the PCA after more than a decade to explore the possibility of strengthening PCA's presence in India. This could see India as a seat or venue for investment treaty cases and promote international arbitration in India. Finally, I am pleased to note that various international arbitral tribunals and institutions have curated regionally diverse panels of arbitrators. I am certain that this diversity is a contributor to the success of these institutions in transcending geographical and cultural barriers. However, the gendered compositions in these panels are hard to miss. We face what is called a diversity paradox. That is, a mismatch between our stated objectives and actual appointments. Less than 10% of all Indian arbitrators on various international institutional panels are women. ICC's 2022 report on gender diversity identified an unconscious bias as contributing to this problem. It suggests using gender-neutral pronouns in our legislation and rules. We have made an effort in that direction by launching the Gender Handbook in the Supreme Court of India just a couple of weeks ago, which tends to replace the gender-skewed language of legal discourse in our legal and judicial institutions. I hope that our Gender Handbook will take the theme of discussions beyond public law into more profitable commercial spaces. It is heartening to note that some arbitration rules have taken the cue in employing gender-neutral pronouns in their texts. However, the overwhelming majority of empaneled arbitrators are men. Women, as persons of all genders, belong also in all institutions of dispute resolution. Speaking of, and more importantly, speaking to some of these issues is critical to the development of law and policy on dispute resolution. I congratulate the organizers for the choice of issues slated to be discussed here. I look forward to the lively discussions that will ensue in the course of this conference. Hopefully, it will be a harbinger for change and a rethink on critical issues which confront us today. Thank you very much.